So it's a problem with trying to fit a square peg, and our children seem to be very much square pegs, into a round hole. It's not that the hammering is hard. We know that it's very hard work for everybody involved, often to parent and support a child with ADHD, but it's that you're destroying the peg when you are constantly trying to shove a child into an environment that that doesn't meet its needs or doesn't suit that child's way of working. And so I think it's important, because really what I'm going to be speaking to you about is all about the ways that we can maybe support and make adjustments as far as is possible for our children in schools, and that we're entitled to ask for that to happen, rather than constantly place demands on our children that they can't meet and then punish them when they fail to meet them, because it's unreasonable to expect them to be able to do that. So for me, and I don't know anyone else here, we're about, what, 6 days maybe into the school term, so I've already had several emails, 2 phone calls and a meeting from school, and I should explain that, as well as my career background is that I was a criminal litigator for about 15 years. It was very useful to have legal skills, but to support my son Dylan. I've got an older daughter who actually has inattentive ADHD, but I didn't have huge problems with her in the sense that nobody phoned me up about her. She just failed in education, but nobody bothered me about it, whereas with my younger son Dylan, who's now 12, he has extremely challenging behaviour, and so it was a real struggle to get his needs met. He's been through a number of schools through permanent exclusion, and so in the end I had to say the only way I can continue to devote my life to fighting Dylan's battles is to upskill myself in this new area of law and become an education lawyer. Luckily, I was at a firm that let me then do that, because we already have a children team here anyway. And so that's how I got into this way of working, because for me ADHD in school equals anxiety for parents, because we as the parents tend to carry the anxiety of our children's actions and have all the stress and the grey hairs to go with them. So it seems to me, whether you bring a hellraiser, which is more like my son Dylan, or a daydreamer, which is much more like my daughter, there are sort of common issues that we are facing as parents trying to deal with schools. So I'm going to talk about some of the support that should be available for our children. I'm going to talk about the Equality Act and the protection that brings, and the tool that it is that we can use it as. Some reasonable adjustments, and I have to confess right at the beginning that I meant to have prepared by today a nice little booklet of 101 reasonable adjustments. For a variety of reasons I didn't complete it, so I will circulate as a little booklet to everybody via Alistair and Val, but we can talk about reasonable adjustments though. Just a little bit I'll touch on dealing with schools, and then talk about some of the action that we can take when things aren't going well, because my view is that action is definitely the antidote to anxiety. So whenever we're just feeling overwhelmed and stuff, usually doing something about it makes us feel better, and occasionally actually improves the situation that we're in. So some of the common issues that I think that we're dealing with as parents with ADHD. So labelling, I don't know if any of our children here, we're parents of children here, have been labelled as bad or stupid or lazy or dumb, but it's a fairly common experience for children with ADHD. Our little guy in the middle there, maybe having a few issues with his social skills, social interaction skills, and maybe keeping his emotions in check and not demonstrating them. The saddest part for me, I think, is this one, that the social isolation that can sometimes go with being different. It's not just ADHD children that experience this, it seems to be fairly common for many children that have a variety of disabilities and differences. My experience is that for most children with ADHD, they don't find it difficult actually to make initial friends unless they have other underlying difficulties, so they make friends fairly well. but they lose them just as quickly as they make them often. Sometimes parents don't particularly want their children playing with our children, and so they often end up socially isolated. Then over there we've got our little chicks. Unfortunately, some of our children get left behind academically for a number of reasons. They're struggling to keep up in the classroom. Mood and just miserableness can be a huge aspect of having ADHD at school, sometimes because managing our mood is difficult for young people with ADHD, but also because our self-esteem gets affected by constant failings or criticisms or labelling or isolation or whatever, and so it can be pretty miserable. My particular favourite experience is sometimes we can't keep our hands to ourselves when we've got ADHD, and so sometimes our hands kind of get in the wrong places, and we use them too much and too frequently in ways that other people don't like. This is the main reason for most of my son's exclusions down the bottom here, is that physical issues, when we can't manage our conflict, sometimes for children with ADHD and adults more with ADHD, which was much more relevant to my former criminal litigation career, it often results in some kind of physical interaction. It's not always that the ADHD child is starting the fight, but they often finish the fight, or they are much more extreme in their reactions, and so often that causes an issue. Being faced with too much work, being faced with work they can't do. Lots and lots of ADHD children have problems with writing and being able to manage being given an essay that's got a lot to it when they're a bit older, and homework seems to be a huge battleground for children with ADHD and their parents to get through. And finally, the one that seems to be most relevant to secondary school is organisation. So my son's now been at secondary school for a year and a few days, and he still can't hand in his homework. He does it, it just stays in his bag, and he never hands it in. And so you know, he often doesn't have a pencil or a calculator or whatever it's supposed to be, and that's with the best will in the world and me making sure that he's got the right things. They just don't go. So organisation is a huge thing, and that many of these things are part of executive functions, and it's not, I don't have time to talk about all of that today, but it's some of the skills and some of the issues with brain development that cause these things to be real problems. But these are all, you know, crucial and essential parts of being at school. So if you have a child with ADHD, you almost certainly have a child that has special educational needs. And I particularly like this picture because, as somebody who has ADHD myself, often you feel like walking around in the world, you've kind of got so much going on the whole time, and so, you know, if people could see it, it might make it a bit easier for them to understand you, but that's kind of what it feels like to me. And I passed it by my son, and he said, oh yeah, no, that's exactly what it feels like. But more boringly, what the law says about special educational needs is that if you have a learning difficulty or a disability which calls for special educational provision to be made for your child, then you have special educational needs. And what is a learning difficulty or a disability? Well, if you have significantly greater difficulty in learning than the majority of other children of the same age, then you have a learning difficulty. And so an example of that is my daughter, who I mentioned to you earlier, who happily is now way beyond the education system because she's 24 now. She didn't learn to read until she was 11. She just didn't get any of the things in literacy in particular that were being taught to her. She just didn't respond in the same way, and at the time, I mean, I was a young mum with my daughter, and at the time I was going through university, and I was like really pro-education, and I just couldn't understand, look, you know, I'm doing all the right things, it's just not working. And you know, and she just had a significantly greater difficulty. You know, she can read now, you know, the age of 24, happily she can read, but you know, she just couldn't learn as easily as other children. So that's a very obvious learning difficulty. But sometimes with ADHD it's more complicated than that, because if you're like my other son, who has an IQ of 151, is a member of Mensa, is hugely bright, you think, well, I can't possibly have a learning difficulty or special needs, but actually he has a disability, and that prevents him from and hinders him from making use of the facilities at school. And why? Because he can't cope with the social interaction and the social environment. Sometimes he can't conform to the requirements that are placed on him within the classroom, and so he's got a condition which just hinders his ability to manage everything else. He has some issues with organisation and some of the other kind of academic skills, but why that's important is because often parents are told, you know, if your child is at whatever the national curriculum level is that is appropriate for their age, then they don't have special educational needs, there's nothing we can do for them. And that's simply not true, because they may just not be able to cope with everything else. Basically, just sort of as a quick aside then, the Children and Families Act came in September 2014 and is the main bit of legislation that covers everything to do with special needs, but there are also regulations and a code of practice, which I'll refer to a bit later on, that goes into lots of detail about what you're supposed to be doing when you're dealing with schools, and there's a particular chapter, so I'll refer to that. What I'll do is I'll attach to the end of the notes a link to all relevant legislation and guidance that you might need, because that's going to be a lot easier than me talking you through bits of different sections. The other thing I'll be talking about is the Equality Act, but I'll talk about that in a moment. So, if you have a child with ADHD, I'm saying that they do have special educational needs, and if they have special educational needs and they don't have a statement, which is the old law, but most people still have one of those, or an education, health and care plan, which is the new document that's replaced statements, then they should be on SEN Support. And SEN Support is what's replaced School Action and School Action Plus. I don't know if that means anything to anyone, but it basically is the group of children who have been identified as having special educational needs. They need something more than the average child in the classroom, the typical child in the classroom, and they have, but they haven't got a statement or a plan, so but they are on a register, so they're highlighted. And this is what SEN Support now is required to provide. So Section 66 of the Children and Families Act, so you know what law it is, places a duty on schools to use their best endeavours now to secure special educational provision. So that means they should really be doing all that they can to provide for your child's needs, and that might be providing speech and language therapy, that might be providing some support in the classroom, that might be just making some small adjustments for them, or perhaps providing some social skills training. But schools are now obliged to use their best endeavours to secure that special educational provision without any additional funding or any additional support earmarked for your child. And the system now is a cycle, and it's assess, plan, do, review. So all children on entry to any school should be and I should clarify, any state school, not any independent school, but I'll talk about independent schools later, should be assessed. All schools should be assessing all children to identify, do they have any special educational needs. Once they've assessed, they should be planning, what are we trying to achieve with this child, and how are we going to do it, what are the steps we're going to put in place, then to actually do it, and then to review it regularly. And they do that in relation to four main areas. So it's communication and interaction, cognition and learning, social, emotional and mental health, and then sensory and physical. So actually the academic learning bit is only one aspect of the things that we should be considering with the assess, plan, do, review. And a record must be kept. So there's a SEN support record should be kept for all children that have been identified as having special educational needs. That should be made available to parents to inspect and have a look at, and parents should be involved in this process. It shouldn't be something that school are just doing on their own. They should be involving parents, because unsurprisingly parents can often add a lot in terms of information about their children and how they can help. Hello, do come in. Hi. There's tea and coffee at the back if you need some. So all staff working with your child, whether that's the dinner lady, if you're allowed to call people dinner ladies anymore, the dinner lady, the playground assistants, the teachers, the senior management team, anybody who might be coming into contact with your child should be made aware of your child, their needs, the outcomes sought for your child, support and teaching strategies. Quite importantly, because teaching strategies can be primarily for in the classroom, but for example, if you have a child who gets overwhelmed emotionally and is likely to act out in some way if they get distressed, it's no good if the person supervising lunch doesn't understand that your child is allowed to walk off without permission and go to their calm space, for example. If everybody is not aware, then everybody's not going to be doing the same thing, and it leads to conflict and difficulties and confusion, actually, often for the child. So the decision to involve specialists now, it doesn't need to wait. Before you had School Action and then School Action Plus, and School Action Plus was where you involved external specialists. So I'm talking about educational psychologists, occupational therapists, speech and language therapists, physios, anger management specialists, potentially CAMs and other mental health services. They can be involved at any stage now, so it doesn't need to wait. Now that's optimistic and ambitious, because that doesn't mean the schools have any huge amount of resources to provide that, and they are usually buying it in. So in this borough, often a school has like a day and a half a term of educational psychologists provision, and so if they, depending on the needs of that school and how many children are in there, they often may not have much resource available, but that decision can be taken at any time. But they must talk to you about it, not just get your child assessed or seen without your knowledge. So as well as that, they must provide an annual report. Well, nothing new in that, everybody gets an annual report, but they must also meet with parents 3 times a year, so on average that's going to be once a term. So for someone in the position that you are, with no statement, no plan, then you should be meeting with the school once a term to go through this assess, plan, do review and actually plan what's going to happen next. But if it happens that when you're doing this assess, plan, do review, it becomes very clear that the school can't meet your child's needs from the budget that they have, that they don't have the expertise or funding to identify needs, because those people that are here in the main are going to have a child that's got a diagnosis or is in the process of having a diagnosis. There are many children who are just either, going back to my original slide, staring out the window or raising merry hell in the classroom, and no one actually knows why that's happening. And it may be that the teaching staff may have an idea of what they think it is, but they don't have the expertise. So they may need to think about who's going to be able to identify what that child's needs are. And in order to be able to identify something, you need to know what it is and understand it. And although things are improving in the sense that there is at least more training available, for example in autism and ADHD, that teaching staff can access, there's no obligation on them to access any of that. It's entirely voluntary, and so often they don't know what they're looking at. They know that they've got a child in the class with issues, but they don't know what they are. But that's exactly the point that I'm just about to make, that if they don't have the expertise or the funding to identify needs or work out what the provision should be, but they know they've got a child with difficulties, or if they can see quite clearly, look, this is a child with what appears to be ADHD, or you've brought in the diagnosis letter as a parent to the school, they know what the issue is, and they know what the provision possibly should be, maybe some one-to-one support, but they can't make that provision from their own resources because they can't afford it, essentially. That should trigger an education, health and care needs assessment. So what used to be a statutory assessment for a statement is now an education, health and care needs assessment, and that's what they should be doing. So if you've got a child in the classroom that either you don't understand, or where there is some understanding but not the resources, then we shouldn't be sticking with SEN support anymore. We should be moving on to the education, health and care plan process, and it's the kind of topic in detail for a different day, but it's important to understand that schools shouldn't just be going, well, we'd like to help, but unfortunately we don't understand, or unfortunately we don't have the resources. If a child's needs are beyond a school's resources, then they should be speaking to the local authority. So just to move on then, education, health and care plans, which is the wordy way of saying statements, as they were, the legal threshold for when the local authority has to carry out an assessment, which you all, if your parents, can ask for, and the school can also ask for, is when the child has or may have special educational needs. And so we've talked about what special educational needs are right at the beginning. So if the child may have special educational needs, and I'm saying to you that if you have a child with a diagnosis of ADHD, or is almost certain to get a diagnosis of ADHD, they have special educational needs, so you can tick that box. And then it's a very low threshold for the next part of the test. It may be necessary to make special educational provision, so it just may be necessary to do more than is available in the mainstream classroom, and it's only may. Unfortunately, what happens when local authorities are asked to assess someone is they think, are we going to make a statement or not? Are we going to make a plan these days or not? If not, we won't bother to assess them. And the problem with that logic is that the assessment actually involves some stuff. So it involves an educational psychologist, involves social services, if there's social service involvement, it involves a paediatric medical, and if, depending on your child's needs, it will involve other things like occupational therapy, speech and language, all of those things. Now, with the best intentions in the world that I'm sure the SEN team have, they're not qualified to assess whether your child actually has special educational needs themselves. They're qualified to consider evidence that's gathered and then make a decision. So it's really important, and also within that, if your child is pre a diagnosis, then CAMS may well be involved as part of that process, because if there's concerns, and a lot of the children with ADHD also have autism, also have anxiety disorder and a variety of other things, so that kind of assessment is really it's really important. So if you write a letter asking if you don't have a plan already or a statement, if you write and ask, they've got 6 weeks to decide yes or no, we're going to assess this child. Then they've got several weeks to do the assessment, and then they come to the decision. So the legal threshold for when they have to issue a plan, and I'm using plan and statement interchangeably because people think I'm talking about an amazing new thing, but actually it's just a reinvented statement. And the legal threshold is, in light of the evidence gathered at the education, health and care assessment, is it necessary for special educational provision to be made? And so the test is as simple as that. And so if you've got a child, the school can't meet its needs or can't identify its needs, then you should be applying for an assessment, and those are the tests. And we can go into that more in detail at a different time. I'm going to talk to you in a moment about the Equality Act, but one of the things I just wanted to say is that I know it's an uncomfortable issue for some people. Is ADHD diversity or is it a disability? And it really does depend on your particular views. My thoughts about it are that in reality, the social model of disability is really helpful, because actually it's the way that society, and let's make that into a microcosm, so it's the way that schools are organised that causes a person to be disabled rather than the fact that they are different. So I understand that, and so I believe that in many respects ADHD is a diversity. However, I have absolutely no hesitation whenever I'm dealing with any professional involved with my son in calling it a disability, and the reason for that is I don't necessarily tell him so much that I think you're disabled, because I don't know how helpful that always is, but certainly when I'm dealing with anyone else I use it, and the only reason is because I want him to be afforded the protection of the Equality Act. And so even if you are one of the people who chooses to think of ADHD as a more positive difference, and there are undoubtedly strengths and positivities, it's useful when you want to have a fight about something to have something to use, and so that's the reason why. And I say that first because I know sometimes people feel uncomfortable with it. So what the law says about disability, well, and this comes from the Equality Act 2010, that a person has a disability if they have a physical or mental impairment, so ADHD is a mental impairment for the purposes of this Act, and the impairment has a substantial and long-term adverse effect. So that's the guidance on that is if it's been going on for 12 months or more, or it's likely to go on for at least 12 months, and if you have a diagnosis of ADHD, your child has had that ADHD from birth, so you're usually going to meet that criteria, and the adverse effect is on their ability to carry out normal day-to-day activities. So for me, an average child, their day-to-day activities involve being at home, being at school, and maybe doing some extracurricular activities. If they are struggling in school, if you are having much more of a challenge in your parenting experience, parenting them, than any other children that you may have come across or had yourself, then those are the normal day-to-day activities. And so in all the case law that, you know, ADHD is specifically referred to in the Act, but it's not one of the automatic qualifications for being disabled, but in all the case law there are various things that go right and wrong for ADHD children in the case law, but in all the case law that in the main cases where often involving exclusions of children, then ADHD is considered to be a disability. So what does the Equality Act do? Well, I like to think of it as a knight in shining armour that comes along and protects our children. Sometimes it's a bit more unicorn-like and doesn't always do what it's supposed to do, so I don't want to give you completely false hope, but it definitely is useful. And so it offers individuals protection against discrimination on the basis of what's called protected characteristics. So for our purposes, we're just really looking at disability, but you will have heard in other contexts about, you know, sexual orientation discrimination or race discrimination and things like that. The Act is the same Act, it's the same law that applies, but we're specifically looking at disability discrimination, and there are some slightly different ways that if it's disability discrimination, the Act works. But the Act applies to all schools, and it applies to the responsible body of all schools. So it's not actually the head teacher who's at the, you know, front line arguing about things with you possibly. It's the owners of the school if it's an independent school. It's the governing body, it's the academy trust, it's whoever is responsible overall for the school, and it's all schools. So if, whereas some of the other legislation and guidance doesn't apply to independent schools because your relationship in an independent school is a contractual one, so it depends on what's agreed between you, the Equality Act is the only thing externally that you can point to say that actually you do have to listen to me when I say this because of the Equality Act. And so what it says is it's unlawful for a school to discriminate against a pupil or an applicant if you're in the wonderful admissions process in relation to admissions, provision of education, access to a benefit facility or service, exclusions, or anything else. So basically anything that you're dealing with a school, then the Equality Act applies to. It's also unlawful to harass or victimise not only the child, but the child's parents or siblings, and sometimes other people in the wider circle because of that child's disability.
Does that only apply to schools, or does that apply outside of schools? It
applies outside of schools. It's a different bit of law, because if you're dealing with most other organisations, and if you want to speak to me specifically, I'll tell you which bit, but otherwise there's a different part that deals with services, so anyone who's providing a service. So for example, to give an easier example, if you're a wheelchair user and you can't access a restaurant, for example, then the Equality Act applies, and it's about offering a service. So this is, but this bit is specifically to do with schools. But yeah, I mean, disability discrimination is the bane of most people who haven't got a disability's life. Because it requires them to have to do all sorts of annoying things to accommodate all these annoying disabled people, and so it applies to other things. So, for example, if there's issues around another service that's being provided to your child outside of school, then this is.
I was thinking on a bus when I've been thrown off buses, been harassed by the passengers, say control the child, and would that?
So your cause of that. So unfortunately, that's likely to be more of a potentially criminal offence if it's other passengers, because, and I'll talk to you a bit about the problem with other children at school, but it's likely to be more that if you're caused harassment, alarm or distress by, so this is where my criminal brain comes in handy, that by other passengers, and it's disability related, then they've probably committed a criminal offence potentially. Your struggle is how to get their details and identify them when you get off the bus. But that's what it is. So for example, if someone, I was about to use some rude words then, but if someone said something racially offensive to someone on a bus, it would be a criminal offence. And depending on what else they said with it, whether it was threatening or just offensive, it would be one of the public order offences. So if you're caused harassment, alarm or distress by something that somebody else does, then potentially, and it would depend on all the circumstances, but potentially that's what you're dealing with. If, however, it was the bus driver who said, I'm refusing to allow you on because your child is doing something very ADHD-ish, because I know that child and that's the one with ADHD or something, then you might have a cause of action against the bus company, the responsible body of the bus company. But when it's other passengers, then the bus company is not generally responsible for...
do they have to know that he has, or they have ADHD?
Knowledge is necessary.
So if you tell them and then they refuse?
Yes. So knowledge, because in order to, so you need to have knowledge. You don't have to have a diagnosis, but you need to have knowledge, because otherwise it's difficult for you to, depending on what bit of discrimination you're talking about, it's necessary to have that. So there are in schools there are 5 forms of discrimination that are unlawful at school, and I'll talk about them in more detail. But direct discrimination, indirect discrimination, discrimination arising from a disability, failure to make reasonable adjustments, which is the thing that's really quite important at school, and then pregnancy and maternity. Now, I laugh a little bit because as a naughty ADHD child, I was a teenage mother, so I think that that's quite useful to have in there, but that's not for most people, though there is an unfortunate co-relationship between ADHD and teenage pregnancy. That's one is the one I'm not going to go into in any detail. So direct discrimination. So people kind of understand direct discrimination because we've got a good history of it. So the kind of signs in the windows, the rude signs in the windows, no Irish, no dogs, no blacks, that kind of thing. These days you might think some schools would like to have a sign that said no ADHD children, but they kind of know they wouldn't get away with it. So generally, direct discrimination is very obvious. So you discriminate against a person directly if person A, so I've put the horrible headmaster, discriminates against another lovely shouting ADHD child because of their disability, so that's the protected characteristic, and treats that child less favourably than they would treat other children who don't have that disability. Now, there's no defence to direct discrimination, but it's very difficult to prove in most circumstances. You need a comparator. So what you need is your ADHD child and another child doing exactly the same thing, but one child gets treated much worse than the other, and that's the ADHD child, and it appears to be because of the ADHD. Or for example, 2 children equally able at football, but one's told, look, you've got ADHD, you're too much hassle, you can't come in. It just isn't going to happen often, but people are going to be that obvious because the world has become too politically correct, which on the one hand is a great thing, on the other hand it means that any discrimination is going to be more subtle, so it's more difficult to show. So direct discrimination, if you can prove it, then the responsible body is immediately guilty, and they are discriminating against. But it's not the one that's used most in tribunals. There are very few, I should say, tribunal cases about disability discrimination comparatively to what you might expect in schools. So indirect discrimination is much more likely to be an issue, and a person, horrible headmaster, discriminates against another nice, sweet ADHD child if they apply a provision, practice or criteria that we call PCP, which is discriminatory against a disabled person. So provision, practice or criteria basically means anything that the school normally does. So it might be a written policy, like a behaviour policy or a homework policy, or it might be a uniform policy, or it might just be a practice that in this school we always do X, we always have an assembly on a Monday and everyone always sits cross-legged on the floor or whatever, so it's not necessarily written down, but so it's anything that regularly happens, like a policy. And that policy is discriminatory if it applies to a person, it applies to everyone, so people who are not disabled as well. So all children have to have their top button done up. That's the uniform policy, for example. All children have to not hit other children, that's the behaviour policy. But there may be indirect discrimination if that policy places disabled people in general, or groups of disabled people, so people with ADHD, at a particular disadvantage in relation to their peers. So for my son Dylan, every school that he's been to has had a behaviour code, and he's had more contact with it than any of his neurotypical peers, because he's impulsive, very impulsive. So he does things without thinking, he calls out, he runs when he's not supposed to run, he hits people sometimes, and does all those kinds of very antisocial things that bring you into contact with the behaviour code. So he's at a substantial disadvantage because of his disability, because it's ADHD that causes him to have those difficulties. And so if the policy would put a disabled person, specifically your child, at a disadvantage, then that is indirect discrimination if they're treated unfavourably. So if your child is excluded or suspended because of acting in a way that's to do with their disability. However, the school has a defence to indirect discrimination, and that's if it can show that it's a proportionate means of achieving a legitimate aim, all legal wording. But basically, if it's reasonably appropriate, proportionate response to them trying to achieve good order in the school, health and safety considerations, if they can demonstrate that they've acted in that way, then they have a potential defence. So it's going to depend a lot on the facts as to whether or not it's proportionate what they've done. And this should also be read in relation to or taking into account reasonable adjustments as well, because it may be that they haven't done all they can before they've got to the point of applying their behaviour code. Now, what was difficult about indirect discrimination is that you need somebody else to compare the child to who doesn't have the disability to be able to see if there seems to be indirect discrimination. What this limb does is it says that if there's discrimination arising from a disability, then they'll also fall foul of this act. And so that's if the headmaster, who I keep picking on, discriminates against our ADHD boy if he treats our ADHD boy unfavourably. So that just means in some way that's not nice, unpleasant, because of something arising in consequence of his disability. So if our little boy's disability causes him to shout out and run around during assembly when he's not supposed to, and he's punished, then that is unfavourable treatment because of something arising in consequence of his disability. But again, there is a defence, and it's the same defence about a proportionate means of achieving a legitimate aim. So if there's a health and safety reason that applies in this instance because the child's behaviour is causing some kind of risk to other children or to himself, then arguably there is a defence to this kind of discrimination. But it's all about, was it proportionate, the response, and what really, was there anything else that could be done instead? And that's where we come on to reasonable adjustments. So the Equality Act places a duty on schools and lots of other places, but particularly on schools, to make reasonable adjustments. There are 3 reasonable adjustments generally, but one is about physical features, so that's about ramps and lifts and those kinds of adjustments. That doesn't apply to schools, but the 2 that do apply to schools is that where a PCP, and you'll remember I talked about provisions, criteria or practice of the school, puts your child at a substantial disadvantage in relation to a relevant matter such as provision of education or access to something within the school, in comparison to peers that are not disabled, then the school has an obligation, it has a duty to do what is reasonable to avoid that disadvantage. So they've got to make some kind of adjustment to their way of working in order to remedy that disadvantage and close the gap. And the other duty that applies is where a disabled person would but for the provision of an auxiliary aid. And just to demystify that, that just means an aid, a bit of equipment, or a service, therapy, a TA, support person in the classroom. So where, but for the provision of some equipment or some support of some kind from a person, will be put at a substantial disadvantage in relation to one of those relevant matters, in comparison to peers that are not disabled, then the school has to provide that service or that equipment. And that sounds great because because theoretically that then means that we can all just have one-to-one support all day long for our children and any aids and adaptations they need. However, there's no definitive list. So a reasonable adjustment is whatever is reasonable to try and prevent that disadvantage to your child. It's not that some things are reasonable and some things are adjustments and some things aren't. But there's a number of factors to be taken into consideration. So you might be thinking that your child needs adjustments in the classroom or in relation to a behaviour policy, and what the law says is, well, we have to work out if it's reasonable to expect this or not. And the factors to be taken into account are what SEN provision is available, because if there's already a plan or a statement or resources within the school that provide for this adjustment that you're asking for, then fine. Then it can be made available. What are the financial resources of the school and any other financial assistance available? What's the other costs of making this adjustment? Do we have to disadvantage everybody else in the classroom in order to make it happen? The effect of the disability on the individual, health and safety requirements, and the slightly annoying one, the need to maintain academic, musical, sporting and other standards. So if we can't let little Johnny run riot because we're trying to maintain behavioural standards in the classroom, might be one of the things that a school might say in response to a request that you, for example, disapply parts of the behaviour code. And then the interests of other pupils and prospective pupils, because sometimes the reasonable adjustment that you're asking for has an effect on the other children. But certainly there are lots and lots of reasonable adjustments, and as I said, I didn't manage to get my 101 adjustments printed, but there are loads and loads of different things that you can ask for. And what we'll do is, when we're doing our chatting and eating at the end, is that we can think about, if anyone's got a particular issue, we can think about adjustments. So some of the adjustments that for example, my son has is that he's allowed to take a photograph of written work at the board. He has 3 different calm spaces over at Hampton Boys. One for if he's outside, one for if he's in the classroom, and one for when he's somewhere else. And so there are places that he can go to that he's allowed to just go to if he gets upset or throws a wobbly. He has other adjustments, and some of them are SEN provision, so he has one-to-one support for certain aspects of the school day. But there are so many things, and whether they're equipment, a wobble cushion to stop fidgeting or whatever, that they're all things that you can certainly ask for, and then you can debate whether it's reasonable or not for the school to provide them. But ultimately, if you reach the conclusion that you're asking perfectly reasonable things and the school aren't doing them, you can point out they might fall foul of the Equality Act and potentially bring a case against the school for disability discrimination if you feel that they're not being reasonable about that, having regard to those factors. So the good news is that the Act permits favourable treatment of disabled people, and I've put there the floodgates argument has no place here. And what I mean by that is that if a school says, well, we can't let little Johnny chew chewing gum, because then everyone will want to chew chewing gum. And for anyone who doesn't know, chewing gum is really helpful if you've got ADHD, because of the energy you've got. Movement actually aids concentration, so whether you're wobbling on a wobble cushion, you've got a busy legs band around your feet, or you're chewing gum, or fidgeting a fidget toy, those things can actually help you to be more calm and more able to concentrate. So when you're told we can't because that will be favourable treatment if we don't punish little Johnny for just swearing at that teacher, then you can point out that actually you're allowed to treat disabled children more favourably, and the idea is that you are equal up, not equal down, so you can assist that person, give them the head start or the leg up and the support to make to make it more of a level playing field. I mean, that's the purpose of the Equality Act, is to make it a level playing field, and if that means raising your child up or giving them a bit of extra help or support, then you're allowed to do that. So so don't accept anyone suggesting to you that we can't do that, you can't treat your child more favourably because they can. I won't go into these bits in too much detail, but just it's unlawful because of the Equality Act to harass or victimise a parent as well as a child. And just briefly, because this is it's the less important aspect for most people most of the time, but it can become a very hot and difficult issue. So basically, a school harasses a pupil if they engage in unwanted behaviour towards that pupil, if they humiliate that pupil, if they point out that they can't sit still, or make, you know, unhelpful, unkind comments about them, and particularly if that violates the pupil's dignity in some way or creates a hostile or intimidating environment for them. So constantly threatening them with exclusion would be one of my thoughts about creating an intimidating, hostile
or making their life a misery for the whole time.
And making their life a misery, you know, and so that can be harassment. It's unwelcome behaviour. You don't have to have said, I don't want you to talk to me like that, but if you create that environment and that atmosphere for a child, then you are actually harassing them. And victimisation is something that's important. So it's if, in response to you carrying out a protected act, so you complaining about disability discrimination, you asking for reasonable adjustments, you making a complaint, you saying to the school, I think that you've breached the Equality Act, or doing anything else, any of your other rights in relation to that act, then, and the school treat you less favourably because of it. For example, in independent schools, sometimes, if you start making a fuss, then they just advise you that you might want to remove your child. That's the way that they work, and it's not considered to be at all unusual. It's like the head teacher is God, and if you dare to suggest that they're not doing things in the right way, then usually they'll just suggest that you leave, and sometimes they'll even offer you your deposit back. And you know, and so if that happens, then this is where parents are protected as well. So if they start treating you as the parent, or for example siblings of that child, you know, they suddenly go from the A team in sports to the D team or something, start making a really you know, unpleasant environment because you've suggested that, then they are you know, they're engaging in unlawful behaviour. It is discrimination because it's victimisation, but there must be a link between what you've done and the detrimental treatment. So if they exclude your child because he then punches and kicks somebody to the floor or something, maybe you're not going to be able to make the causal link between you know, making a complaint about something and the exclusion, because there's something else that's happened. But if there's nothing else that's happened, then you probably can make the link, and it's victimisation, which is unlawful. So my favourite thing then, exclusions. It's unlawful for a child to be victimised or discriminated against by being excluded from school, and that includes informal exclusion. So if anyone's been asked to take their child home or collect them early,
tell you how many times.
That's an informal exclusion, and so informal exclusion's fixed term, so for a few days, known as suspension still in some schools, or if it's permanently, they're not allowed to come back. You're not allowed to victimise and discriminate by way of exclusion, but it's not unlawful to exclude a child with ADHD, unfortunately. I would really love that to be the case, but it's not unlawful to exclude a child with ADHD if the circumstances are appropriate, but an exclusion would be unlawful if it was because they have ADHD or because of manifestations of ADHD, so behaviour, for example, as a consequence of ADHD. But there's the defence, this annoying defence again of proportionate means of achieving a legitimate aim that comes into play. However, schools must make reasonable adjustments in relation to exclusions and in relation to disciplinary sanctions. So if, for example, there's a 3 strikes and you're out policy with a particular school, and they get to their 3rd strike and they're either excluded or not allowed to go on the school trip, for example, then that may well be discrimination because they haven't made allowances. They haven't, you know, they might need to make it be more strikes, or they might just need to not apply a strikes policy and just apply a risk management assessment to that particular child. Now, if your child's in a state school, which I've put as maintained schools there, then there is additional law and guidance that applies to them, and I won't go into that in detail today, but there's a lot of procedure that has to be followed, and there is also education that needs to be provided to your school, your child, while they're not in school. So it's important to be aware of that. It's important to be aware that none of that applies if you're in an independent school. It's just a contractual relationship. However, the Equality Act, remember, does apply. So if you've got a child with ADHD in an independent school and they're being excluded, then apply the Equality Act. And I should just say that there is loads of detailed guidance available. There are documents produced by the Equality Commission. There's also various charitable, most of you will know that I do voluntary work for IPSE, a national charity, and it's IPSEA, IPSE, and they have brilliant materials on there, available to the public, that you can go and look at, that talks you through all of this stuff. So have a look at it and see, and if your child's disabled and within the exclusion something seems to have be indirect discrimination maybe, or discrimination arising from a disability, then rely on it, and you've got nothing to lose. And the tribunals can order reinstatement of your child into an independent school, can order them to have training and make up time in terms of extra tuition and stuff like that. Unfortunately, and I didn't actually do a slide on this, but they can't order compensation for the pain and suffering that you are caused. There is no compensation, and in most circumstances they won't order costs either. So if you've instructed a solicitor and paid them loads of money and you win your case, you don't get your money back unless the responsible body have acted completely unreasonably, and it's quite difficult to act completely unreasonably in legal proceedings. It's just important to bear that in mind in terms of.
So it's called the
the IPSE. It's IPSEA, and it's a charity that provides. It's a national charity that provides advice to parents and loads of other people actually with special needs. But it's just useful because sometimes you're not sure, and if you don't remember everything I've said, or you've lost the slides or whatever, sometimes it's useful just to actually go through it and say, well, this is what happened. He wasn't allowed to go on the trip, and take yourself through and see if you can work it out. So, bit of bad news. There is a regulation called Regulation 4 in the Equality Act, and you see that I think it's quite evil. And the reason I think that is because what it does is it says that you're disabled, you have the protection of the Equality Act. However, right at the beginning we talked about the impairment aspect of disability, and what it does is that what this regulation says is that if your child has a tendency to physical or sexual abuse of other persons, then they're not entitled to protection of the Act if what's happened, if the detrimental treatment to your child is solely because of their tendency towards physical abuse. So for somebody like me, that's a real problem, because although my son actually these days is not doing too much punching people in the face, he's more just sort of swearing and storming off, he was doing a lot of hitting out at other children, and so that causes a problem. Now, I haven't got time to go into the details of this. There's a lot of case law going on around whether this regulation should apply to children and schools or not, because arguably it shouldn't be applying. Mainly, these cases mainly involve autistic children or children with ADHD whose challenging behaviour is an integral part of their condition, and they're being excluded. And this regulation is sometimes preventing them from having the protection that they need from the Act. And so IPSE, which also does a lot of campaigning and changing of legislation, was heavily involved in amending the Children and Families Act before it became law, are doing a big campaign at the moment to get the legislation changed so that this applies, because if you bear in mind that the Equality Act applies to workplaces and adults, you can kind of see if someone's going around punching people at work, that's kind of a bit different. If children have developmental delays like ADHD, then is it fair that they're not entitled to protection of that because they're an autistic child that's flapping and they hit somebody in the face, So I just say beware of that, because it just means when you think you've got your watertight disability discrimination case, you just need to check whether this regulation might apply. And as a lawyer, I find ways around this, because often it's not just, they'll say we're being excluded not just for the fight, but the fight was the last straw. It's also other things, and so we can do stuff, but I won't bore you with that now. Clearly, if they've got a tendency to set fires and stuff, then that's a difficulty. That's a difficulty as well. But I just bring that to your attention because it's a real pain. So I'm slightly over time, but anyway. So how to deal with schools, and I'm not doing a lecture on how to deal with schools because lawyers aren't any good particularly at any better at dealing with schools. So I say this part really more as a parent. I went to a course quite recently, where a big educational conference, and one barrister spoke for an hour about how to deal with parents, in particular difficult parents, things like sight bans, how to exclude them, injunctions, and basically how not to have anything to do with these horrible parents. And it was very interesting because it was important to think, because we might think schools don't know what they're doing and complain about them, and local authorities. It's very interesting to see how we're seen as parents, and often we're seen as combative because we go in and shout our mouths off about what we expect to be happening. Often we're seen as overprotective. If only we just give them a little bit, of space and stop fussing, then everything would be much better.
My son would be dead.
Yeah, well, often that's the case, but unfortunately, it's not always seen like that. And otherwise, the helicopter parent, I think I probably fall into the helicopter parent because I always think I know better than the teacher, so I kind of regularly want to sort of oversee what they're doing and see if they quite understand all of the issues. And so often that's how we see it, and I think it's important to bear that in mind, because I think how we approach schools has a bearing on the response that we get. And so if you kind of are aware that they're all allergic to parents, because they've had bad experiences in the past or whatever, it's important to bear that in mind. So, and I sort of apologise that my slides are getting worse by the second, but I was taught how to do PowerPoints by my son, Dylan.
Brilliant.
So I say, it's really important you definitely catch more flies with honey than vinegar.
Yeah.
So even if you are absolutely, what you really want to do is go up and punch that teacher in the face because they've really upset you and they're really not doing the right thing by your son, having a positive, friendly, I learnt this as a lawyer because I come from a very rough background, and problems were solved where I grew up by punching people. But what I learned through being a lawyer is that you have to be polite to your opposition, and everyone has to talk nicely and be pleasant. And it really helps to have that kind of training in your mind, so that you don't accidentally become the unreasonable parent that you are then considered to be the problem. And often you're exasperated, you're desperate, you're exhausted, and so sometimes you've got undiagnosed ADHD yourself, or you've got diagnosed ADHD. It kind of doesn't really matter, but as far as is possible, then my advice is to be reasonable. And the other really important advice is to be reasonable in emails and letters, because if you ever want to bring a case against a school, or if you ever want to raise a complaint in some of the other ways, be sure that your email with your capital letters underlined, red, angry words will be in front of a person who's making a judgment about you. And the best defence to Equality Act claims seems to me to be the parent is a nightmare. If you had to deal with that parent, you'd understand. So although it may seem obvious, maybe it is more obvious to other people, but maybe just not me. I think it's so important to be polite and friendly. Always start off, your emails. Thank you so much.
Presents help.
Sorry. Presents help. Yeah.
Really help.
But also just always saying thank you so much for whatever it was. Really appreciate your time in the meeting. Yeah, all of that kind of stuff. It's not, even if you don't mean any of it, it's just really helpful. The other thing, knowledge is power. So you're obviously here today to get some information, but there is loads more information out there. When you're dealing with schools, then Chapter 6 of the Code of Practice, so I'll send this round, is really useful because it sets out what everybody's supposed to be doing, and going to the IPSI website, going to talks and things. If you know not only about your rights and law and stuff, but you also understand ADHD and any other condition that your child might have, then you're going to be in so much a better position, because actually most schools that I come across don't know what their obligations are. the local authority definitely don't know. There's people working in the local authority definitely don't know what the law says that they're supposed to be doing, and so you can't trust the professionals. Not because I actually don't believe that there's, you know, it's because people are bad-minded or have, you know, any kind of sinister motives. I just believe it's usually incompetence, and unfortunately that's incompetence that could affect very, very significantly your child's life. And the other thing down the bottom, in case it doesn't make sense, is to keep a paper trail.
Yeah.
So if every meeting that you have, just send a nice little follow-up email, very politely, just so we discussed this, we agreed that I raised with you this issue of, you know, maybe you could do these. You don't even have to call it reasonable adjustments, you know, but I suggested maybe this would be a good idea, because you're keeping a paper trail so that whenever you need to defer to a higher power, you've got that there. And also, whatever school promised that they said they would do, you want them to actually do it. And the other thing is that if you don't have a statement or a plan already, and you think you might want to apply for one, you might want to get one, then you want to have a record that all these things have been tried already, and, you know, there's no progress being made. So it's really important that you put everything. It doesn't come naturally to everybody. Sometimes it's really hard to do that. You might need to find a good friend who's prepared to help you with letter writing. But just a quick email, and I find emails better than letters because they've been because you can see that they were actually sent. What if your honey isn't sweet enough? What if you've said all the right things, you've been really nice, you bought them presents, you know, you gave them books on ADHD and all the rest of it, and it doesn't work? Well, there are a number of things you can do. So the first thing you usually need to do, you usually need to have exhausted this, but for disability discrimination claims to the tribunal, you don't have to have done this. School complaints procedure. So the general rule is, you talk to the teacher doesn't listen. You talk to the SENCO, doesn't understand. You talk to the head teacher, you make a complaint to the head teacher gives you an answer that is unsatisfactory. You then complain to the governors. The governors then say they don't uphold your complaint. You then ask for them to escalate it to an appeal, which most schools follow the same procedure, including independent schools. Independent schools look at what their complaints procedure says, but most of them follow the same procedure, so you'll end up with an appeal panel hearing, and that's where your paper trail comes in really, really handy. None of that works for a state school that includes academies and free schools. You can complain to the Education Funding Agency or the Department for Education, and there's specific legislation that you are using, but it's for breach of statutory duty or unreasonableness. So if you've tried everything else internally, you can then complain. It takes a long time, but they do have some power. Local government ombudsman is more for, it's very limited, but you can complain when, for example, the school's not delivering provision in your statement. Usually you have to have a statement or a plan before they are very helpful. Ofsted is not for your individual complaints, but if there is something systematically going wrong in your school, then you can raise the issue with Ofsted, but it's not going to solve your individual problem, but it's raising concerns. We've talked about education, health and care assessments or a SEN appeal. If the statement or plan is not doing its job properly, it probably means it needs changing, so the description of needs in it or the provision needs changing. We've talked about various bits of discrimination, so the next thing is you can bring an Equality Act claim to the tribunal. It's called the first tier tribunal now. People talk about it as the SEN tribunal. It's free. It's supposed to be user-friendly for parents without lawyers. The idea is lawyers are not supposed to be involved. That's not actually true, because if you make a claim of disability discrimination against any school, independent or private, they will instruct lawyers, they will instruct barristers, because reputational damage is huge. Nobody wants to be found to have discriminated against, particularly not a disabled child. It makes really bad news headlines. But it's supposed to be used, and you shouldn't be put off, because the tribunal are helpful. The SEN tribunal are helpful in the sense that they will guide you in the right direction. The forms are fairly straightforward, and also bear in mind that if you don't have the resources or the inclination to instruct lawyers, then IPSI, and there's a few others, but IPSI I talk about because I trust and because it's what I do voluntarily, they can in some circumstances provide you with help to prepare your claim and help to actually represent you in the hearing. Judicial review is a last resort, which basically means going to the High Court. and it's used where somebody's acted outside their powers, mainly, like a local authority. What's good about it is that there's legal aid available, because the legal aid, irrespective of your means, the legal aid application is in the child's name, and so unless your child happens to have a huge trust fund and a great income, then you can get legal advice for free, and so that's much better. So I've talked already about the distinction between state and independent schools. Independent schools, it's a contractual relationship. Most of the SEN guidance doesn't apply, so the codes of practice. Some independent schools will talk about things as if they do apply the special educational needs policies and regulations and stuff, but they're not obliged to follow them, and so it doesn't matter what they say, they're not obliged to follow them. It's a contractual relationship, so it's only if they go outside of what you've agreed in a contract that they are in breach of contract, unless you're dealing with the Equality Act.